Welcome to the I Got Fired podcast, a podcast for folks who have been fired or afraid that they might be. My name is Tom Spiegel. I am founder of the Spiegel Law Firm and host of this podcast. Little legalese to get out of the way that we do every time. This is for your educational purposes. It is not meant to form an attorney-client relationship with the Spiegel Law Firm or to be legal advice specific to your case. And that's right. If that's what you would like, then you need to go hire a lawyer. You're certainly welcome to call our firm. We also have a lot of resources on our website to help you think about how you help you find counsel for your case, if that's what you want. All right. So now that we have gotten the fine print out of the way, today's episode, we are going to be talking about the demand letter, and we'll talk in a minute about what that means. It's essentially the initial letter to your employer asserting your claims, and why it is important. One of the most important pieces of it is who that letter is addressed to. So let's get into it. So the way that a lot of employment cases are handled is the initial stage is this is less true if you work for the federal government, but most of us don't work. Most of us are in the private sector. I should also say, as an aside, one of my attorney friends saw this podcast and made fun of my headphones. Said he was going to start a GoFundMe page to get me appropriate equipment. I guess it does make me sort of look bug-light or a pilot, but let me know what you think. Do I need different equipment? I don't know that I can be helped. But in any event, the way most of these cases start is with a letter to your employer. It's called a demand letter because usually what it does is at the end of it, it says, this is what I'm demanding to resolve this. So it'll start out with, kind of a statement of the facts, who you are, and, go through kind of what happened to you and what violations of law. And again, this can be through you, or if you're with like our firm, it'll be coming from your attorney, laying forth what laws were violated, and then there will be an ask at the end. There isn't always an ask at the end. Sometimes we will send letters just setting forth what we know because we are inviting a response from the other side so we can get a sense of what their position is before we lay out some kind of demand. Nevertheless, that's what they're called. They're called demand letters, and in many instances, there is kind of at the bottom of the letter, asking for money or some other kind of relief, a transfer, new boss, an accommodation, whatever it may be. And that, of course, the meat of that letter is very important, right? What exactly happened, what violations of the law you think occurred. But one of the most important parts of that letter that is sometimes overlooked is who you send it to. Who is on that, who is in that to line. And this is where it can require some judgment, and where having an attorney can make a difference. So let's talk about it. And often it will vary depending on, the employer, how big your employer is, and what your relationship is with whoever you may be sending this to. So let's say that it's a smaller employer, or somewhere where if not everybody in the company, a lot of people. You've been there a long time, and you're going to be addressing this to, often it will be to a manager or to human resources. Not all companies have a human resources department, but a lot of them do, and so you can address it to somebody in human resources. And you may know that person. I've certainly had clients who were relatively high up, and they had worked, let's say we're sending it to the, senior vice president of human resources, fairly high title. And I've had my client who has worked with this person for a number of years. They've gone to lunch together. Like I said, they know each other. So in that instance, your letter's going to get read, and when I say there's judgment involved, there may be some value, even if you have an attorney advising you behind the scenes, and you sending that letter yourself because you have a personal relationship with this person. Having it come from an attorney, kind of ups the temperature, which can be a good thing, but it may be something you don't want to do in the first instance, because I've had clients had successful outcomes where they knew the person involved. They were able to send them, a professional but personalized letter, and even had a follow-up conversation with the person involved. I even had a case this number of years ago where we ended up filing a lawsuit. So this is well past the demand stage, and this was a high-level person within the company. She knew the owner, and the owner was off doing other things. Was not intimately involved with this case. And really, the first time he heard about it was when we had mediation before a judge, and he was required to be there. And when she kind of, my client and through me kind of laid out what happened and what our ask was, I mean, he was, and this is rare, but this is an example of what happens when you have a personal relationship with somebody. I mean, he turned to his attorney. He's like, what are we doing? Let's settle this case. And we settled it on very good terms. I mean, his attorney was, you could see, kind of frustrated in the moment, because she was like, hey, she didn't quite come out and say this, but essentially like, we've got defenses here. And he's like, I don't care. Like, she was with us for a long time. Maybe we should have handled this differently. And we settled it right there at a really good value. So again, if you have a personal, or, the person you are sending that letter to, that can make a difference with in a smaller company. So you want that to go to the person, particularly there in HR, who or could be even the owner of the company. Now, it doesn't always work. It doesn't, you don't always get a sympathetic audience. Sometimes, of course, there can be bad blood, right? Familiarity breeds contempt. So maybe your history is not always good. And in that instance, you might be better served by having an attorney send that letter. But regardless, that letter is going to be read and there's going to be some response to it. Now, if you are in a company where, let's say it's a larger company, you don't know the higher ups, or maybe in the handbook it says, if you're going to make a request, it has to go through human resources, and you're sending it to human resources, either to somebody you don't have a personal relationship with, you just found their name on, on the website, or you're sending, kind of like to whom it may concern. And sometimes you have to do that, right? Sometimes you don't know who is the best person to address that, and that's the only way to do it. But in those instances, the demand letter is less likely to resolve the situation or to get you a real satisfactory response, because usually the person receiving it doesn't know you, and even if they do, they don't have the juice within the company to, for instance, maybe give you a better severance package or whatever relief it is that you may be asking for. I mean, this is just somebody in HR, and they can be good, they can be not so good. Regardless, their job is to be there to protect the company, and they don't have the authority, even if they wanted it, to kind of write you a check. But you're not going to know that, and so you may get some response, some completely unsatisfactory response, back from HR if you send that kind of letter. Again, that doesn't mean it's not worth doing, but to keep your expectations in check as to what kind of result that you are going to get. The other thing to think about, and why it's important, like who that to line, who the letter's coming from. Is it coming from you, or is it coming from the attorney, and who that to line is. And in a lot of instances, what you're trying to do is get to the company's attorney. Either the company has somebody in-house, or they have an employment lawyer that they deal with, and you're trying to get it on that person's desk. Now, that doesn't happen with every company, particularly smaller companies. They may not have somebody on retainer, but they can certainly hire somebody, or will. You're trying to get to that person because he or she is going to be the one to be able to have the sway with the company to get the company to write you a check, or to do something that the company in the first instance may not be inclined to do, right? Because you can't, if the letter goes to HR, again, some HR people are very good, but a lot of them don't know the law. They are doing mostly administrative tasks. They're dealing with healthcare benefits, whatever, something other than being able to analyze the company's what we call exposure. What are the chances they're going to lose at trial? And even an attorney who's in-house, who's kind of a jack of all trades, and who maybe is involved more on what we call the transactional side, the business side, the contracts and those sorts of things. Even that kind of attorney may not be able to fully evaluate the company's exposure. Often he or she will know that and will bring in or consult with somebody who does have employment law experience. If it's a really big company, they may have their own employment attorneys that are in-house that will help them evaluate that. But you're trying to get it to that person, because that person, if there's going to be a result, and they're not, just because you get in front of the attorney doesn't mean that there will be. The attorney is going to be there to protect the company. And, kind of the behind the scenes conversation that typically happens is the attorney is having a conversation sometimes with the owner, if it's a big company, the board, or somebody lowered down the totem pole, but with enough power to be able to resolve this case, and giving the person within the company kind of their unvarnished opinion about what the company's looking at. Hey, Joe, I'm reading this letter. If, we need to do some of our own research on this, but if this is close to true, we could lose this case in court. We might want to think about trying to resolve it. Or, I've read this letter, I've talked to some people within the company. I don't think there's any exposure here. I'm recommending we take an aggressive tactic and that we don't offer anything, or something in between, right? Like, I don't know if we can win this or not. It's going to cost the company $100,000 to defend against this case. So, maybe we want to come up and offer them something, just to get this to go away. Because while we may have defenses, we still might lose. And regardless, it's just not worth fighting over. This is where it comes into having a reasonable demand on your part. Kind of going through the legal leverage program, which is available on our website, to get a sense of what your number is. The lower that number is, the more likely that you're going to be able to get a positive response and get it resolved. The higher it is, the more likely the company is going to go to the mattresses to defend it, which may be okay. If you've got a really strong case, you may be prepared to do that. I'm not suggesting you have to lowball yourself. But in any event, that's a conversation that might occur between the attorney and the company. It's probably not going to happen with HR. If HR gets that letter, they're going to do their HR thing with it. They may not even show it to an attorney. You never know what's going to happen. And it's going to get bounced to you with some kind of unsatisfactory response. That's where, in some instances, it can be helpful to have an attorney, because if you have an attorney send it, again, it's not that the company necessarily is going to run quaking, although they might. Depends on the company and what's in that letter. But you're more likely to have that letter sent to the attorney for the company and get some kind of traction. Not always. Companies will stonewall lawyers just like they will stonewall their former employees, but you are more likely to get that letter in front of somebody who can actually do something and help get the case resolved. So that is why it's important. Who is on that to line? If you're sending to somebody even if they're not an attorney with the company, certainly if you're sending it to the owner. Again, I had a client some years back who knew the owner of the company, and we sent we initially sent a letter to somebody higher up in HR, and we're dealing with their attorney, and we were getting some traction, but not as much as we wanted. And she went into his office and just had a heart-to-heart with him, and he, she kind of diffused the situation. I mean, he was a little bit of a hothead, and she knew that, and so we knew the more that we pushed, the more likely that he was going to get backed into a corner, and not resolve it short of a lawsuit. And she went in and talked to him, kind of face to face, and she was able to get it resolved. So again, if you've got a personal relationship with that person, you're more likely to get traction, when you send the letter, whether it's you sending it or it's coming through a lawyer. And again, if you're working with a lawyer behind the scenes, this happens not infrequently with us. We're not gonna raise our head yet to say, hey, we're representing you. We're just advising you behind the scenes. You're sending the letter because you have a relationship with that person, and you may be able to appeal to them based on your long history with the company in a way that an attorney who's coming in, just looking at the legal angle or just asserting that within the letter may not be able to. So that's kind of one, two, the person you're sending that letter to. That's one way that you can kind of think about the best way to do that. The other one is you're sending it to somebody within the company you don't have that relationship with, perhaps just somebody in HR. There's less utility in you sending that letter by yourself. Sometimes you can get traction with it, but you're more likely, if it just lands on HR's desk to some nameless, faceless person to you, that they're either not going to respond or you're going to get something satisfactory, because they may not even know enough to be able to, they may not even decide to send it to the company lawyer. They're just trying to bounce it back and get it to go away. And if you're at a really large company and you're sending it to whom it may concern, what you're trying to do is get it to somebody who you can have a conversation with. I mean, even if it's not in person, through correspondence, whether that's the right person in HR or more ideally the company attorney. In those situations, if you're working for a Fortune 500 company and you send a letter on your own, it's not coming through counsel. I won't say there's 0% chance, but there's very little chance that you're going to get a big move, if any move from the company now, because it's just going to go to be grist for their HR mill, and you're not going to get some kind of positive response. So it's really helpful in that situation to have it come from a lawyer, because, ideally it's going to go to HR, who's then going to bounce it to, inside or outside counsel. If you know who that person is in the first instance, then of course you can address the letter to him or her, which is ideal. I'd like to skip HR when I can, if at all possible. Can't always be. Sometimes we don't know who the lawyer is. Sometimes it's unclear who the lawyer is, and so we have to go through HR first, or somebody who can help us identify who that person is. If your letter is coming from a lawyer and we know who the attorney is for the other side, then we have to send. We need to send that letter to the attorney. The lawyer is not able to have a conversation or not able to reach out to an unrepresented party in the company. In this instance, we treat them like a person, and if we know the represented, it has to come to their lawyer. If you, the client, the former employee, you can send the letter to whoever you want. You're not constrained in that way. So that's why in some instances the to portion of that letter can be the most important part. All the facts and all the law. I mean, the truth is that you can, with ChatGPT or with some research, you could probably get 70% of the law right on your own. And it's not going to be a mystery to the attorney on the other side if they know anything about employment law. They're going to know what the anti-discrimination laws are. This is not going to be a mystery to them. So the law section is I wouldn't say unimportant. It is important, but it can, in some instances, be less important than getting to the right audience, somebody who can be a real decision maker. And if it's somebody who you have a history with or can appeal to on a personal level, in the first instance, that can be, again, if you have a decent relationship with them, can be very helpful. So when you're thinking about, whether you're sending the letter on your own or you're going through counsel, absolutely people need to know what the facts are. We need to look at the law. But remember, one of the crucial factors as to what kind of response you're going to get from that letter, whether it's going to help move the needle or not, is who you are sending it to. So I hope you find this helpful. Before we wrap up, I want to remind folks that we have something called the Career Rocket newsletter. It's free. You can find the link into it in the show notes. In fact, we have a whole separate website for it. And we are through that endeavoring. You'll get free emails in your inbox that will have the latest and greatest in employment law, but not only that, but tips and tactics to help get your career to the next level. Because what we want to do is, even for people who are experiencing problems at work and they need a lawyer, and that can be important, your resume writer and your life coach, they're not going to be able to move the needle if you're having legal problems at work, but they're an important part of the conversation. You want to get on to that next better job, put your career on an upward trajectory, because it's one of the biggest resources that you have in your life, and we want to give you the whole picture. So not only what you need to know about the law, but what you need to know about best practices, about operating within the workplace, remote work, what are the best tools, monitors, those sorts of things to make sure you're really kind of on the balls of your feet at work. And if you're in the market for a new job, what are the best tips and tactics, for instance, for writing a cover letter or dusting off your LinkedIn profile, those sorts of things. So the Career Rocket will provide you with that. Look for the link in the show notes. It is free. I urge you to sign up. Thanks, everybody, and good luck out there.